Good afternoon. We are excited to dive into our session recap for 2026. My name is Jackie Muick, Consumer Advocacy and Website Manager here at Maryland Realtors. Our expert panelists are here to give you all of the information about what housing legislation did and didn't pass in Maryland and how it affects the industry and your business. With us, we have Lisa May, our Director of Advocacy and Public Policy, Kristen McGee, our Grassroots and Policy Advocate, and Bill Castelli, Maryland Realtors Contract Lobbyist. We are looking forward to answering your questions. Please submit your questions through the Q&A box at the bottom of your Zoom screen. We will be answering all questions at the end of the webinar. This webinar will be recorded and sent out to all registrants after the conclusion of the webinar, and you will be able to find it on the Maryland Realtors YouTube channel. So if you miss our email after this, feel free to look there and see if it's already up. And with that, I'll hand it over to Lisa.
Jackie, thank you as always, and thanks to everyone for being here. It's a beautiful day, literally and figuratively, to talk about realtor and real estate legislation that passed in the 2026 General Assembly session. We're going to hit some of the highlights here today during the hour that we have, but we also have other resources available for you if you want to see the full range of real estate legislation that was considered by the General Assembly. That is available on our advocacy priorities page on mdrealtor.org. And we'll also have an article coming up in the next issue of Maryland Realtor Magazine that we hope that you will check out. But for now, we're going to go ahead and get started. So I'm just going to share my screen here. And we'll kick this off with two of our realtor priorities that passed the General Assembly and were actually just signed into law this past Tuesday in a signing ceremony at the State House. And coincidentally, both of these bills were updates to legislation that realtors first passed back in 2023. First being earnest money deposits. Realtors first sought to streamline the EMD return process in a more limited way back in 2023 by applying it only to a set number of the most straightforward contract contingencies. Since then, we've heard from our members, from our instructors, from brokers, that, this process is working really, really well. Is there any reason why it can't apply to all contract contingencies, namely the big one being financing contingencies? And so that's exactly what we did. Expedited EMD return as of October 1 will apply to every contract contingency that exists within the transaction. In addition, we also clarified that if a seller is going to dispute the return of the EMD and are going to seek mediation, they're required to provide a copy of a notarized written request for mediation that has been provided to the mediator, right? In plain language, this means it's not enough to just tell the escrow agent, hey, I'm going to seek mediation. You have to actually do it. And that closes just a little loophole that some folks were taking advantage of in the process. And then finally, for escrow holders, once the seller dispute period has ended, or once you receive that notice that the escrow can be released, you no longer have 30 days to return the funds. That's now a 5-day return period. Puts those funds back in the hands of buyers much more quickly so that they can move on to their next transaction. And then the second bill that was one of our priorities that we worked closely with the bill sponsor on, it involved homeowner benefit agreements. And just by way of review, a homeowner benefit agreement was a product that started to show up around 2022, not just in Maryland, but in multiple states across the country. A property owner received a nominal upfront cash payment, sometimes several $100s, maybe even up to, say, $1,500 in cash. And in exchange, they agreed that whenever they sold that property next, anytime during the next 40 years, they would use a particular real estate brokerage. If for some reason they didn't use that real estate brokerage, they owed this company a 3% penalty And these agreements were recorded as liens against the property. We recognized, and many, many others recognized the issues that this would cause within a real estate transaction. And that is why we sought and passed in 2023 the National Model Bill from the Land Title Association to prohibit these agreements. Here's the catch. Legislation, when you pass it, typically is not retroactive. We don't come after the fact and say something that was legal when you did it is now illegal, and we're going to hold you accountable for that. So what that meant is there were 1,000 of these agreements that were recorded before the effective date of that 2023 bill. And they are still out there. They are still out there recorded on these properties and are now starting to pop up in transactions, not just for home sales, but also for mortgage refinancing. So what's the issue? Well, since 2023, the real estate brokerage that offered these has gone out of business. So the property owner cannot list the property with the broker, which was part of the agreement. And the company which collected the 3% penalty is no longer in good standing with SSTAT and the comptroller. So what does that mean for these property owners? Well, it really has been creating a cloud on the title. Like I said, some of them have not been able to sell. Some of them have not been able to refinance. So we knew that we needed to do something to help them. We had to get a little creative. So what we said was, if you have an agreement that you entered into before 2023 when the ban took place, and the company that provided it is no longer in good standing, and the agreement has been in place for 2 years, it cannot be a lien. It cannot be recorded on the title. And if it is, it's void and unenforceable. Extra kicker is that if the company does try to enforce it while they're not in good standing with the state, the property owner can take them to court, and they can seek damages, including legal fees, and any other penalties that they have incurred from having to deal with this agreement. So this bill really can save property owners thousands of dollars, maybe even $10,000 plus, and help them to move on with a property sale or a refinancing if they need to. It is really a bill that will help people, and we're very, very proud that we were able to get this through the General Assembly and passed. And now I'm going to hand it over to Krista.
I was the next slide, Lisa.
I'm sorry, not Krista, Bill.
Alarm.
Good afternoon, everybody. I am going to talk first about flood disclosure. This was a bill that we supported with amendments. So the original bill that came in needed some work. We proposed a bunch of amendments to the legislation, which the sponsor accepted. What the bill basically does is seek a flood disclosure. And so every seller that is going to be selling their property beginning on July 1st of 2027 is going to be required to provide the buyer, before entering into a contract, a flood disclosure. And it has the same kind of exceptions that the current seller disclosure law does. So it doesn't apply to, for example, estate sales, transfers between related parties, things like that, that the seller disclosure exempts. But for most other residential transactions, it would apply. And what it does require is that, basically two things: that you give a risk disclosure form that the Maryland Department of Environment is going to develop, and I'll talk a little bit about what that form is going to ask for, and if available, a copy of the FEMA elevation certificate for the property. So what the form is really asking people to disclose is whether they're within one of the what's called a special flood hazard area, which is a 500-year floodplain, or moderate a moderate risk flood area, which is the 100-year floodplain. There are at least two websites that anybody can go to. One is a FEMA site, one is actually a Maryland Department of Environment site, where you can enter an address in on the website, and it will actually pull up a map of, it's basically a FEMA map, a DFIRM map, that will show whether that property falls within one of those areas. So it'll be fairly easy for sellers, agents representing sellers, to figure out whether those properties are affected by those. And if they are, and a flood elevation certificate is available, then you would give that to the buyer before the contract gets signed. The form would also ask a couple of other questions, mostly related to whether there has ever been flooding on the property. And we're talking not about whether a water pipe broke, but whether the seller has knowledge of basically past flood damage where you received aid from like FEMA or U.S. disaster assistance. It'll ask things like, do you have any flood insurance, whether it's NFIP flood insurance, private flood insurance, and then also, again, whether there's an elevation certificate. In many instances, there may already be an elevation certificate on the property, especially if the property has flood insurance. So that would be important to find out. If the seller already has one, then they can provide that to the buyer, and the buyer is not going to be required to actually purchase one. And then the seller's also got to disclose whether they know about any claims filed for flood damage. But again, it's really from like specific natural flooding events. We're not talking about broken pipes and things like that. And again, they'll take the next year developing the form, and then this requirement goes into effect July 1st of 2027. Builder disclosure requirements. So this was legislation that we also supported. This bill is similar to the open house disclosure that real estate agents have. So this would apply to home builders and their sales representatives. So if you're a sales representative representing a builder in a model home on site, then you would be required to now provide a disclosure or notice. It could be a placard, it could be a piece of paper on a table. It's got to be done in a very conspicuous way. And that disclosure's basically got to inform those buyers who are coming in to look at the property that as a buyer of a new home, they have a right to obtain their own independent representation to navigate that new home buying process. They will also be informed that that selling agent, that representative of the builder, is there to represent the interests of the builder. So again, the form is seen as an important notice to purchasers of new properties that if they want their own agent, which may include a realtor, then they have that right to do so. That law is actually going to go in effect as of October 1st of 2026, so this fall. And then septic inspections, that is a bill that we actually opposed this year. It did not pass. What the bill would have required is effectively an inspection and pump out for tenants of properties that are on septic systems, as well as purchasers of properties that are on septic systems. There's a couple of little different requirements. I won't get into details, but it would have required before that tenant moved in or before the purchaser purchased the property that there would at least be an inspection conducted. It would be on the landlord for the tenant, their responsibility to order it and make it happen. If it was a purchaser, it would have been the responsibility would have been on the purchaser to order it, pay for it, and then have a pump out done of that property. There were some different time limits, or restrictions in the bill, so that if you had the system pumped out before and inspected within 3 years for a tenant or within 5 years for a seller, you wouldn't have to actually do it again, as long as that inspection was done within 3 or 5 years of either renting the property or purchasing the property. There were certain exemptions that were put in the bill as well for family transfers and things like that. But the bill was mostly opposed in the Senate. This is the second year that it has gone down, mostly due to Senate opposition. So I do expect it to be back next year.
All right, thanks, Bill. And with that, we'll move back into condo and HOA. And this is a bill that, or an area that's pretty active kind of throughout the General Assembly every year. A lot of bills are introduced. Not a whole lot of them seem to make it all the way through the process, but these actually did. The first of these is Senate Bill 747. And where this bill came from is that there are a growing number of situations where there are gaps between what the association's master policy covers and what the individual unit owner's policy covers. And when those gaps exist, you have all of the residents of the condo association picking up costs that rightfully probably should have been the responsibility of the unit owner themselves. So this bill sets out a couple of requirements for the association. Once they start to convey units for sale for the first time, the association has to maintain appropriate property insurance based upon the development type, whether they're attached condos, detached condos, a mix, and whether they're covering the common areas or whether they are covering the units as well. They also have to maintain general liability insurance for things like death and for disability, injuries, things of that nature. Then the association is going to notify unit owners once every year of what that unit owner's insurance requirement is, whether the association requires them to hold an insurance policy on the unit or not, and also what the deductible of the master insurance policy is for the whole association. Those are the association requirements. Now, when we come to the unit owner, if there are damages that originate in a unit, the owner is going to be responsible for one of the three things that you see on the screen. It could be the cost to repair or the deductible of the master insurance policy or $25,000, whichever is the lowest. So we're setting essentially a cap right now is going to be $25,000 that a unit owner could be on the hook for if there is damage that originates within their unit. So for those of you paying attention, you might know this used to be $10,000. And the reason why this went up is because it is increasingly hard for condo associations, particularly large ones and particularly attached condominium associations, to find an insurance policy with deductibles as low as $10,000. They actually almost don't exist. Their deductible is much higher than that. And that is where the association ended up bearing a whole lot of these costs. You also know costs to repair things, cost of building materials, cost of all of those things have gone up exponentially, and $10,000 is not what it once was. So really, if you are representing people, condo owners, condo buyers, what you need to be aware of is they could be on the hook for $25,000. So the owners are going to want to make sure that they can cover that, whether through an insurance policy or whether through other means, if the worst of the worst happens and some damage to the condo originates within their unit. We also had some bills on EV charging equipment. And this has been an issue in some condominiums that have bans on EV charging or other really difficult provisions within their governing documents, within their bylaws. we all know how difficult it is to reach the required threshold to change governing docs and to change bylaws. Could be 75, could be 80%. And when you can't change those, the association's hands are kind of tied. And that has been the case with this. You have some associations who would like to install a couple of EV charging stations for residents in the common spaces, and they've been kind of hamstrung from doing that. So this would say, doesn't matter what your bylaws say, doesn't matter what your governing docs say. If the governing body, going through their normal public process, wants to install some EV charging stations, they can do it. They still have to go through whatever vote and hearing that they would need to do to alter any of the other common areas. They would need to study whether there are enough non-EV parking spaces within the development to handle that need in addition to the need for EV chargers. And they could contract with a third party to install those chargers for a period of not more than 3 years. And then finally, there is going to be a study on condominium buildings that are 40 plus years old. You might say, wait, why 40 years? Well, this goes back to the reserve study debate and concerns about the ability for older buildings that need to fund their reserves. Also, buildings where there's a large percentage of residents who maybe are elderly or are on fixed incomes. It can be very difficult for them to get their reserves up to speed, particularly if that's something that was not at the top of their agenda, maybe something they weren't as vigilant about in the past. So this study is going to look at a lot of characteristics of both the building and the residents that live within them. Maryland Realtors supported the bill, but we were also able to secure some amendments that protect the identifying information of condo residents, their age, their income, and made that more of an aggregation of the building as a whole, as opposed to breaking out individual member characteristics. We thought that that was an important protection for those residents. All right, this bill, guys, I die a little bit inside every time I have to talk about how this great bill, this realtor priority, this issue that frustrates all of you very, very, very nearly came to pass, but fell just short at midnight on sine die. As you can see, this would be a very big overhaul of the resale disclosure packet fees that are allowed to be charged, putting essentially what is a $250 cap without CPI adjustments on that resale packet, conforming some clauses between the condo and HOA acts that are currently out of alignment. We've introduced this bill at least since 2024. Usually the General Assembly says, thank you very much for bringing it. We're going to set it to the side and just deal with some other issues. This year, it got traction. It got through the House unanimously. It got over to the Senate. Every vote that was taken on this bill was actually unanimous in favor, except for the very last one where we just ran out of time to even bring it forward to the Senate floor before that midnight clock hit and the bill turned back into a pumpkin. But we know that this is important to you. We know that this is important to your clients. We are going to keep working on this issue in 2027 and for however long it takes after that until we are able to get a little bit of traction on this, a little bit of relief for what we have heard from you are the abuses that kind of take place during this resale process of charging additional fees, of playing some games with delivery timelines. We want that to end. And that's something that we are going to keep working on, going to keep building upon the movement that we saw this year within the General Assembly. All right. Now I'm going to hand it over to Krista for real this time and not give her a heart attack when I wanted her to explain the wrong bills.
Yes, let's no heart attacks for Krista, please. I appreciate that. Good afternoon, everyone. So I'm going to talk about these next few bills all kind of fall within the same theme, and that is protecting the integrity of real estate records and addressing concerns around squatting, fake leases, and deed fraud. Oh my. So last session, the Maryland General Assembly, they did pass Senate Bill 46, which created an expedited unlawful detainer court process to remove squatters from dwellings. Now, this session focused on those who facilitate placing squatters in homes. The first bill I'm going to discuss is House Bill 765, and this bill responds to the growing concerns about these rental scams, the falsified lease paperwork, unauthorized occupancy claims, and squatting-related disputes across Maryland. Before this bill, fake leases were already illegal, but they were not specifically listed in Maryland's counterfeiting law, which meant that prosecutors generally had to charge the conduct under broader criminal laws such as fraud, forgery, or theft by deception. Now, House Bill 765 and Senate Bill 82, they add residential leases and rental agreements to the counterfeiting statute alongside the documents that are there already, such as checks, deeds, and powers of attorney. As a result, knowingly creating, possessing, or using a counterfeit lease is now treated as a specific felony offense. Yay. This gives law enforcement and prosecutors a clearer tool when someone uses a fake lease to claim occupancy, delay lawful possession, or complicate an eviction. This next bill I'm going to talk about is the task force to study deed fraud. Now, House Bill 130 created this state task force that will study deed fraud in Maryland, and they're going to recommend better tools to prevent, detect, and respond to fraudulent property transfers. The task force is going to take a deeper look at deed fraud in Maryland by studying how often is this deed fraud happening? Where is it happening? Who's being targeted? How are the perpetrators carrying it out? And what other states are doing to prevent it? From there, the task force is charged with recommending tools to better detect deed fraud and policy changes to help combat it in Maryland. The final report is due July 2028, so we have a little bit of time. Stay tuned on that one. Finally, House Bill 810 and Senate Bill 168, they fit into the broader conversation around squatting, forged leases, deed fraud, and the need for more reliable ways to verify property records. Now, this bill does not create immediate statewide blockchain system. Instead, it requires a study to evaluate whether blockchain-based technology could be a useful tool for securely recording and verifying real property ownership and leases. With better digital verification, a blockchain-based system could eventually provide a faster and more reliable way to check whether a lease connects back to the actual owner or authorized property manager. The findings from this study are due at the end of this year, December 31st, 2026.
All right, tenant screening. So this was a bill we were not happy about. This bill passed and really applies to any tenant who is using a voucher. So think Section 8 vouchers, think veteran vouchers, also applies to nonprofit. So if they have any kind of rental voucher that helps them pay the rent, this bill would apply to them. And what the bill does is really seeks to limit the use of credit reports when a tenant with a voucher is applying for property or applying to lease a property. So the bill would say to a landlord or property manager that you can't use a credit score or lack of a credit score to determine a tenant's viability in terms of being able to rent that property. You can consider adverse credit history as opposed to an actual score itself, but only during the time that the tenant did not have the voucher or during a time that the tenant had the voucher assistance. So what they're trying to suss out is, yes, there are certain tenants that have had poor potentially credit histories before they got the housing assistance. So what we think is fair is that once they've gotten the housing assistance, that you would be able to look at their credit history and other records in order to determine whether they can afford to pay the rent and whether they would actually be a good tenant or not. So the other thing the bill makes clear is that you as a property manager, as a landlord, can use a rent to income ratio. They do clarify that if you're going to use a rent to income ratio as a standard, it's got to be applied to all tenants, whether they are a tenant with a housing voucher or not. So if you're using 25% rent to income ratio or 30%, whatever that is, it's got to be the same for the person with the voucher and the person without a voucher. It also clarifies that when you are calculating that ratio, it is only based on, for the voucher, this is for the voucher tenant, it is only going to be based on that section of rent that is not actually covered by the voucher assistance. So if your rent was $2,000, the tenant had a voucher for $1,000 of that rent, you would be using only $1,000 that the tenant is responsible for as that ratio calculation. And then it also allows certainly for all tenants, the use of any kind of commercially reasonable or non-discriminatory use of previous records from landlords, so that if a tenant has a record with a previous landlord, you can call them up, see if they were a good tenant. You can take a look at the court records to determine whether the tenant's history of violating lease, whether there was a record of that. You can use that in order to determine whether that tenant is a good liability moving forward. You can look at their failure to pay utilities as well as creating that kind of record of whether they're a viable tenant, and also whether there's any record of them creating kind of a nuisance or damaging the property, which would also be available in court records. There's a second section of this bill that applies to landlords and property managers, or I should just say owners of property of 6 or more residential units in the state. So this would not apply to all landlords of single family rentals, but if you have 6 or more in the state, then this would apply to you. And what it would do is it requires you as a landlord to put in your lease a statement that if a tenant wants you, the landlord, to report positive rental history to a credit reporting agency, then you would be required to do that. It does allow you to charge for that. So you can charge whatever the actual cost of making those reports are, not to exceed $10 a month. But if that tenant wanted you to report that information, then you would be required to report it. There are a couple other things that you should know about. Regulations have to be issued for this. All of the effective date of this bill is October 1st, which is a very expedited time frame for regulations to be passed. So I'm not really sure whether the state agency is going to be able to get a regulation online within that time period, and that regulation would just apply to the positive reporting of payment records to those credit reporting. The other interesting thing about that section of the bill too is that you are only reporting positive payment history. So let's say, for example, a tenant missed a month or was late, then you theoretically wouldn't be reporting anything that month. So there will be, when you're looking at these, when the credit reporting agencies are recording this, then you would be looking at those gaps within that rental record, because presumably when it hasn't been reported, those are times where there was not a positive rental payment record reported. So again, bill takes effect October 1st of 2026. So tenant screening criminal history. This was another bill that we opposed with, I think, all of the other landlord tenant groups. We worked on it. They made some changes to address some of the concerns that were raised, but honestly, none of the changes moved us off of our opposed position, but the bill still passed. And what it does is it limits the use of criminal histories when you are actually reviewing a tenant's viability to rent a property. There were already some limitations placed in Maryland law. You could only go back 7 years under current law in terms of looking back of what their criminal history was. And this sets up a process where you will actually have, for certain violations, criminal violations, the requirement, not necessarily a requirement to do a conditional offer, but if you do a conditional offer, then you will be able to consider these other criminal violations. There are certain violations that can be considered whether you're offering a conditional offer or not. Those violations are, if you think about serious felony violations, it would include rape, sexual offenses, child pornography, murder in the first and second degree, human trafficking. If that person is a registrant on a state sex offender list or any state sex offender list, then those are theoretically items that you can use that you can tell that person that they would not be eligible to rent that property in the first place. If you do that, the tenant will have the ability to go back to you and say, hey, look, here's some mitigating reasons why I think that violation of murder in the second degree was committed, 40 years ago. I'm a changed person, et cetera, et cetera, et cetera. So they would have that ability, and the law permits them the ability to raise that again with the landlord. But again, it is up to the landlord in order to determine whether those mitigating factors, carry weight in terms of moving forward with them in terms of the tenant application. So that's a separate class of crimes under the bill. The second class of crimes under the bill apply mostly to felony convictions within 5 years immediately preceding the rental. So those kind of lesser felony violations that weren't included in the first list. You can take a look at that criminal history. You can use it as part of your determination for whether that tenant gets that property or not. But you can only look at those criminal violations and only consider them in terms of that tenant viability if you give them a conditional offer to rent that property. So once you've done that, you can take a look at those convictions, including any prior convictions of, like, say, murder that they didn't disclose in the first place. And then you would be able to make a decision based on whether you're going to move forward. The bill does require that or does permit a landlord to withdraw a conditional offer based on felony convictions, but you would have to demonstrate that the withdrawal of the offer is necessary to, and I'll quote the language here, fulfill a substantial, legitimate, and non-discriminatory use. Now, that is a standard that is currently used under the disparate impact analysis. So this is a standard that most property managers, most landlords should be familiar with. HUD has issued guidance. The National Association of Realtors has also issued guidance to landlords, making sure that when they're looking at criminal records, they're doing it on a basis where they're taking a look at very specific instances and any mitigating factors that a tenant may be able to raise. So if you're operating under the conditional use, you can consider withdrawing the offer. You may withdraw the offer. You've got to tell that tenant why you withdrew it. Tenant also has the ability to contest that. And then you've got to be able to demonstrate to that tenant why that withdrawal of the offer was done for purposes of protecting the property or other tenants on the property. This bill also takes effect October 1st of 2026. Last requirement is air conditioning requirements for rental units. This bill was based on two local laws that passed, one in Prince George's County and one in Montgomery County. The bill applies only to residential units in apartment buildings with 10 or more units. So this would not apply to many of the single-family detached rental properties that many realtors represent. And it doesn't apply to any property that's listed on a National Register of Historic Places. But the bill would require for new construction units moving forward as of June 1st this year, or as of June 1st of this year, they would have to have air conditioning in those units. So if it's 10 or more individual units, building with 10 or more individual units, they would have to have air conditioning in them. It would also apply to existing rental units as well. So if you had an existing rental unit in a building of 10 or more that already has air conditioning unit in it, or air conditioning of some kind in that unit, as of January 1st of 2025, then you would be required to continue to provide that air conditioning as of June 1st. The bill takes effect for all other properties, so existing properties that don't have any air conditioning, on October 1st. So again, there's a June 1st date for new construction, and a June 1st effective date for properties that already have air conditioning. Then for all of those other kind of resale properties or existing properties that don't have any air conditioning, the effective date would be October 1st. And what that requirement would be is that after October 1st, if that unit is going under, or the building is undergoing any kind of substantial upgrade of electrical systems, heating systems, then they would have to actually provide units for that property. And those units have to be able to operate from June 1st to September 30th. They've got to be able to cool at least to 80 degrees. The bill does not specify that it's got to be a central air unit, so it could be a window unit, but it does have to be able to cool that unit to a minimum of 80 degrees. And I am done on air conditioning units. Good cause lease renewal. So this is a bill that the realtors have opposed for, I can't even tell you how many years, probably over 20 years. The bill did not pass this year. And what the bill would do is, it is regarding any tenant who is in a property right now. And as you all know, every lease for every unit in Maryland right now has a start date and has an end date. Could be a month-to-month lease, could be an annual lease. But that date that lease terminates is the date it terminates. This is a bill that says, no, if a lease is going to terminate, you've got to, you, the landlord or property manager, have to tell that tenant why you are terminating, why you're not going to renew that lease. And you have to have certain reasons, and only certain good causes are going to be considered reasons to terminate that lease. So if you don't have a good cause to terminate that lease, you've got to continue to you've got to continue to extend that lease, regardless of the fact that lease has a termination date. And this is a door that only swings one way. You don't, as the landlord or property manager, you don't have the ability to kind of unilaterally extend the lease. Only the tenant does. Now, they did put in a lot of different provisions in the bill. They made it a authorizing bill for the local county, so it would not apply to a statewide, it would not create a statewide requirement, but it would authorize counties within the state of Maryland to move forward on a good cause lease renewal bill. They like to call it good cause eviction, the tenant advocates do, but this is clearly not an eviction. It's just the end of the lease period. And they did work on the bill to create a series of good causes. So it includes any kind of minor infractions of the lease, substantial violations of the lease, non-payment of the lease, renovating the property. There's a whole list of different provisions in there of why you could terminate the lease, but you would have to communicate that to the tenant and let them know. That bill did not pass. I do expect that bill to be back in one form or another next year. There's another bill on statewide rent control. This bill also did not pass. We were very opposed to it, as well as the other landlord tenant groups. This bill would have tied rents on all single-family residential real estate. And I think what the sponsor intended was that it was detached single-family residential real estate. So exactly the kind of properties that most realtors are involved with. But it wasn't worded that way in the bill. So it would have applied to effectively all apartment units in the state of Maryland. And it would have tied the maximum rent to HUD's fair market calculation. And if you're familiar with what the HUD's fair market calculation is, that is the calculation that they use to determine how much voucher payments are going to be and other types of rental assistance payments are going to be. It's based on 40th percentage of gross rents for regular standard quality units. So this is not an average rent. This is a below average rent. Or the last sales price. There was a calculation for using the last home sales price of that property, but it would have effectively lowered rents quite substantially for some units, especially using that last home sales price if that property sold with 20 years ago. So this was a really extreme bill. It did not pass committee. I don't think it will be back in exactly the version it is in before you today, but I do think that we're going to continue to see, with housing affordability being a problem, we'll continue to see rent restriction bills. The final bill I'll talk about is family daycare and rentals. This bill also did not pass. It was a bill that we opposed and had problems with. It was designed to address an issue where a tenant who had a daycare and had actually talked to their landlord about conducting a daycare within that rental unit, that this was a single family home, and this bill only applied to detached single family residences that are rented. And that tenant actually, or the landlord actually agreed to allow the tenant to conduct a daycare in that rental property. Well, when the landlord sold the property, the new owner basically told that tenant they could no longer continue to conduct the daycare on the property, which created a lot of problems for people that were sending their kids there for daycare. But instead of just having a bill that addressed that kind of narrow, specific instance, what this bill did, it said that any tenant in any single family detached rental property would be able to have a daycare in that property, regardless of whether the landlord agreed to it or not. So if you, as an owner of a property, have insurance, oftentimes your insurance doesn't even permit home-based businesses. So at a minimum, you would have to at least change your insurance policy on the property. So the bill did try to address some of those concerns, but it didn't make enough changes to the bill that we ever removed our opposition to it. I'm not sure what's going to happen with the bill. This is the second year that it did not pass. It has passed out of the House both years, has not passed the Senate, although this year it actually didn't even finally pass the House. It was special ordered within the House and it stayed on a special calendar and never got a final House vote. So it actually fared worse this year than it did the year before. So I think there's a chance that may not come back next year, or at least not in the version that's before you today. And I'll end there.
Right. And daycare affordability and availability still being a main, kind of topic generally in the General Assembly. But, at least this shows that not every landlord tenant bill and outcome was bad. We still had some good, some good kind of wins on landlord tenant. I'm actually going to take a minute here because the reason why I handed it over to Krista was because I think I skipped over her slide. So I'm just going to scroll back up here and see if I did. Hey, look at that. There's the slide I was supposed to give to Krista. So I'm just going to let her, shine right now and cover for my mistake. Krista.
Well, I don't know how much I'm going to shine in discussing licensing bills, but I shall try to follow the paths of those who just went before me. So thank you for bringing up my slide. So several bills this session focused on reducing barriers to occupational and professional licensing. The first of which, and this one is a repeat bill. It passed last year. It didn't make it to the final. Well, it was actually vetoed last year, but it was signed this year. And it creates a predetermination process for certain occupational licenses, including ones issued by the Maryland Real Estate Commission. And in plain language, give someone interested in pursuing a professional license but has a criminal history a way to ask early, will this conviction prevent me from getting licensed? And for those aspiring to become a real estate licensee, this change could mean that they could pay a $100 fee, obtain an early review before they invest their time and money on pre-licensing classes and passing the exam, only to find out at the end that a prior conviction may be a barrier to them obtaining their license. So this does not change the Maryland Real Estate Commission's ability to deny applicants who have committed crimes not fitting a real estate licensee, but rather it creates a clearer front-end process so that applicants are not left guessing until the end of the licensing process. Second bill I'm going to discuss, Senate Bill 150, that allows state licensing agencies and boards to include a veteran status notation on a licensee's public profile, so long as the licensee chooses to disclose that information. That means when a consumer uses a state licensing lookup system to verify a professional, the profile could also show that the licensee is a veteran. This could appear on an online license verification pages, individual licensee profiles, or searchable licensing directories. For those of you who are veterans, and first of all, after just having Memorial Day, I want to thank you all for your service. But here's a sweet treat. This could be one way to distinguish yourselves when consumers are verifying credentials or choosing a licensed professional. Additionally, the enhanced visibility of the veteran status will also allow those who choose to receive benefit-related outreach if they choose by state agencies. Just kind of streamlines the communication for them. And finally, licensing portability. Now, these bills are both very similar. They created a limited licensing portability pathway for people who relocate to Maryland because of their federal service obligations. Senate Bill 418 and House Bill 1120 applies to foreign service members and their spouses, while Senate Bill 242 applies to active service members and their spouses. In both cases, an eligible individual who already holds a valid out-of-state real estate license may be able to continue working in Maryland without starting the licensing process from scratch. Now, this is not automatic. The individual first has to apply to the Maryland Real Estate Commission or other licensing board, because this is not just applied to real estate licensees, and provide proof of the assignment or their service orders. They have to certify that their out-of-state license is in good standing. And they are limited to only practicing within the same scope that is allowed by their out-of-state license. And they also, of course, have to comply with Maryland standards. They have to fulfill continuing education requirements, and they are subject to disciplinary action by the Maryland Real Estate Commission. Thank you.
See, I told you we're gonna make it up. We're gonna make it up. All right. We're going to bring it home now. I'm going to go back down here to housing because you guys want something to sell. You need inventory. Your clients need a place to live. We need to stop losing residents to other states. Just some of the reasons why we have been so engaged on housing supply legislation at the state level over the past, 3, 4, 5 years. And we did have some wins. The first being the Housing Certainty Act. This came about because Maryland is known as, quote unquote, a late vesting state. And in terms of vesting of essentially property rights that you are granted for your development application, essentially, if you're trying to build a new housing development in Maryland, we can change the rules on you all the way up to the time that you actually put the shovel in the ground. So while you're going through all your permitting, your environmental reviews, all of your feasibility studies, we can say, we know you needed to do these things, but now we want you to do these other things too. Or maybe we want you to scale back the number of units that you built, even though we told you you could build more previously. And That means that building housing, if you're a home builder, if you're a developer, and you are looking nationwide on where to put your dollars and your investments, Maryland is riskier and it is more expensive to build those housing units here than it is in other states. So this bill really wants to change that by putting us on more equal footing with what other states do. And this says that, yes, local governments, you set your qualifications for new development. That's fine. If a developer brings in an application and they meet all of your requirements at the time that they apply and are approved, you can't change the rules on them for 5 years. They can rely upon that approval and build according to that approval for a period of 5 years. The second thing it does is it also delays the payment of any required impact fees, development fees that are owed from currently that can be due at the time of application. We're going to push this off and not collect those until you are going for your final inspections and applying for your certificate of occupancy. And that helps to bring down costs too, because developers will often have to finance those impact fees and those other development fees that are owed over several years of the development. That raises costs. It also creates, again, more uncertainty because you are fronting money not knowing what houses and whether this development will actually come to fruition. So we think that these two things together, and the development community believes this too, will certainly help make Maryland more attractive to national home builders, to even in-state developers willing to take the chance of building new housing here in the state. The second bill that passed, one that's going to be a little more limited in scope because it is regarding transit-oriented development. Now, you may or may not know that within the state of Maryland, the largest landowner is actually the state of Maryland. And so if we're looking to build more housing, those parcels are a logical place to begin. So this bill expands mixed-use housing near rail transit stations with at least hourly service or above, and on land that is owned by either the state of Maryland, the city of Baltimore, or WMATA. It allows these sites to be developed under an opportunity zone program. It reduces parking requirements within the direct radius of the rail station, limits height and setback requirements for those developments, and gives priority to state loan and tax credit programs to help jumpstart those units that are in direct access to our public transit stations. And then finally, we have the Bring Back Main Street study, and I'm going to emphasize the word study on this one. This bill started out as an action bill of allowing residential uses in commercial areas, but allowing an action bill to come forward would not really be the Maryland way. Instead, we are going to study things that are actually occurring in other states across the country. So DHCD is going to conduct a study of residential and commercial zone laws that are already in effect in other states and give us a report in December, hopefully to preclude legislation that would be introduced in 2027 and beyond. Now, you can see a lot of ambitious housing bills here that did not pass. These are the ones that would really lift current zoning restrictions on property owners, that would return some of their ability to use their properties in ways that make sense, in ways that fit the way that people are living now, to fit the types of housing that have sort of gone by the wayside, but that are strongly, strongly needed. starter and silver homes, places for folks who are just starting out, places for people to downsize, our own middle housing bill. We've made a lot of progress. We actually have made a lot of progress on housing issues within the past 3 to 4 years. But this is just a reminder that we aren't taking the big swings on housing. We aren't doing the transformative things that other states are doing. And as a result, our housing market is not as strong as it could be. And whether we are actually going to get in the game and do the innovative things instead of just the easier things, I think that remains to be seen. But no matter what, the realtor voice is going to be very, very important in that process. There are going to be plenty of people to show up and support the status quo. We have to be the ones to show up and say, actually, guys, regulations in Maryland have just gone a little too far in one direction. We need to bring this back to an equilibrium so that our residents can get the housing that they need here in our state instead of having to go find it in another state. That's a bit of a downer. I'm sorry for that, but we are going to actually end on some good news. And I don't know how many of you were already familiar with Bambi, but we're going to get real familiar with it right now if you were not. Over the past few sessions, I mentioned, the big housing bills kind of fell by the wayside. And one of the reasons for that is the advocacy of MACO. MACO being the Maryland Association of Counties. It is the association of county elected officials, just like Maryland Realtors is the association for realtors. They have been our nemesis on this. Whatever we are for, it seems like they have been against, and they've used their muscles to, essentially kind of scare the General Assembly into backing off on some of these. But something interesting happened at the end of the 2025 session. The General Assembly finally said to them, look, guys, you can't just come in here every year and just say, no, 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 we don't want this, we don't want that. You might need to bring forward something that you can support in housing, because this is an area where we need to act. And so in the fall, this was circulating around, and we got a copy of it. This was their proposal. And I know that first bullet point is probably grabbing your attention right now, right? A 4% cap on realtor commissions, not per side, per transaction, okay? And the only way it could go above 4% is if both the buyer and the seller agreed. But beyond that, they also thought these things would somehow make housing more affordable and more available and jumpstart building, which is a slew of tax and fee increases, restrictions on who you could sell properties to, just a host of really, really bad ideas. Thankfully, we have very strong partnerships with our local associations. So Maryland Realtors partnering with your local realtor associations, we got to work before this bill was even introduced in January. Those local associations started reaching out to their county officials to determine whether locally, whether your county commissioners, whether your county boards, whether your mayors and councils, do you guys actually support this bill? Is this really what you think about realtors and the housing market and what's going to make things better? And the result of that was, before we even got to the General Assembly in January, that 4% cap on realtor commissions was out of the bill. Nowhere to be found. They didn't even try to introduce it, which is great. You have a win on a bill before you've even started. The other thing that happened was the House sponsor, because typically, a bill like this, you would have a House version, a Senate version. The House sponsor said, you know what? I don't even want this bill to go to a hearing. I'm going to pull it. I don't want to move it forward. So those are two really great things. Those are two very positive developments. So we were left with the Senate version. The Senate version has its hearing, and we were very forceful, and other housing providers were very forceful in our opposition to this. Not just because it wouldn't do anything for housing, but we said to the General Assembly, you made a promise to your constituents at the beginning of this year that you would not be raising taxes and fees. So if you pass this bill, you're actually going to break your promise to those constituents. You cannot pass this bill as is. And they listened. Coming out of that Senate hearing, they removed all of the taxes, all of the fees, all of the restrictions on who you could sell to and when. And just those two things at the bottom was all that was left of the bill once the Senate committee and the full Senate was done with it. All right, we get through crossover with all the Senate bills, move over to the House. Just these two little things, I think 5 pages were left of the original 30 that were in the bill. They had its hearing in the House committee, and the House committee said, no, thanks, but no thanks. We don't even want to deal with just this little itty bitty bit that is left. And so that is just a really good example of why advocacy matters, why us being involved, both in and without the General Assembly, why great coordination with our amazing local association GADs and leadership and staff are so important, is because without it, you get things like this that are in no way positive for you or for your clients. So with that, I'm going to stop. And I know that we had a couple of, big surprise, Bill, landlord tenant questions, which we're going to circle back to. So why don't we go ahead and do that? I'm going to go back up here. If I can find landlord tenant, here we go. We'll have this screen up while I go ahead and read off some questions for you. All right, Bill, voucher question. Sometimes the voucher doesn't cover 100% of the rent, and the tenant has to cover that remainder. In these cases, could you consider the credit score under this new bill?
So the answer is no. You would be able to verify, use a rent to income ratio. You'd be able to look at court records to determine, whether they've had non-payment issues in the past, whether, breach of lease, any kind of filings against them. You'd be able to go back and take a look and talk to their previous landlords. So if they've got a tenant history that you can refer to, but you would still not be able to use the credit score in that instance. And you would actually be able to look at utility, their payment history on utilities for, because those utilities typically are not included in rent too.
And good question here. I understand the logic in this one. Is there anything that can be done to increase the amount of rental application fees, since now there is so much more work going into running the application, figuring out what you can verify and when?
That is a great question. And, it's not something that's been discussed with the committees. So I don't know. That's something that I think we can talk to legislators about and our legislative and policy committees about. I can tell you that, we've had kind of broader conversations on landlord tenant, making it clear, a lot of times the tenant advocate groups come up and they say, well, these voucher folks are having trouble finding housing. And it's really the credit report that's causing the problems for them finding the housing. And what we've tried to stress with them over time has been, Correlation is not necessarily causation. You want to know who else is having trouble finding affordable housing? People that don't have vouchers. So there's a lot of, I think, misunderstanding of what's going on in the marketplace. People, tying, things like a credit score to the reason why someone can't find a property. So we're continuing to have those conversations with legislators and hopefully to educate them about these broader issues within the market. But we're happy to have that conversation on the application fees.
Yeah. And then we have one bill on rental reporting. Is there any landlord liability if the reports are not filed? Like if the tenant wants the reporting, maybe the landlord misses that, doesn't do that every month. There's some sort of disconnect between what the tenant says is their good history and what the landlord actually reported.
So there is not a specific liability, like a legal liability beyond being able to be fined up to $500 per violation. So it's not necessarily a $500 violation, but they would be able to have that recourse against a landlord if it was not done.
Got it. And guys, if all of you that I see that are still out there, if you have questions, please keep putting them in. We will hang out as long as you want us to, as long as you have things that you want to know. Had a good question about the status of our online disclosure portal legislation. And it's a great question. And thank you for paying attention to our legislative priorities document that we put out every year. Online disclosure portal is a concept that we have been talking about for a couple of years now. It seems like every session, or at least every other session, you guys get another paragraph added to the contract of something that the seller needs to disclose, or a site that the buyer needs to go to see whether the property is within some certain area or subject to a certain condition. And what used to be a very short, contract has now grown longer and longer and keeps growing longer and longer. Meanwhile, folks are glossing over all of those words in the contract. And, we thought, hey, it's 2026. The state has this amazing GIS mapping software system, online portal. Wouldn't it be great if we could put some of those disclosures, particularly ones that are mapped, particularly, ones that have an online component? Wouldn't it be great if we could put those into one database at the state, where you go, you enter in the address, and it shows you just the things that apply to that property? And we know that the technology exists. Here's kind of the complicating factor. You all might have heard that Maryland has some budget concerns, budget issues, budget shortfalls. Developing something like that is going to take time, and it's going to take money. And when bills come in that have a fiscal note, they get a little extra, kind of side eye, a little extra consideration there. We've also had some committee reshuffling that occurred back in December. So the committee that bill was set to go to, all of a sudden now it's going to a different committee. So it is still on our radar. It is still something that we would like to get to, but we also have to be realistic of the sort of political and budgetary realities of what the General Assembly is going through right now. What it may be is we do enabling type legislation to say, yes, this can be provided through an online database, and then maybe we build that up over the years. But yeah, it's going to continue to be something that we're working on. It makes way too much sense in 2026 to keep doing it the way that we're doing it. So thank you for that question. Let me see here. Good question. Thank you, Jen. So thinking of the different segments of our industry that are represented in the bills, is there a way to make more talking points for us to use to educate the public? Very good. Yeah, we have been on our advocacy page of our website. We have kind of a full session recap of a lot of these bills, just a couple sentences on each, but they're broken down by category, similar to how our slides are here. But yeah, we have been talking about, maybe we need to get a few more narratives, a few more case studies, not just the facts and the figures, but kind of tugging at the heartstrings of here's why this bill impacts someone this way. So yeah, we thank you for that suggestion, and yeah, we'll keep working on that. So thank you, Jen. And Leah, yes, the advocacy page of our website has that full session summaries document. It also has a summary of our priority issues, which are kind of the big ones, our realtor priority bills, good cause, rent control, those types of things. Both of those are already on that advocacy page. And as we mentioned, look for our upcoming article in Maryland Realtor Magazine, which should be hitting your mailboxes within the next week or two. All right, I'm scanning the Q&A, and we might be going once, going twice. All right, sold. Well, look, guys, thank you so much for sticking with us today. I very much want to thank the rest of our advocacy team, Bill Castelli, Kristen McGee, also our webinar host, Jackie Muick, for keeping all the tech running here today. If you have ideas for legislation, if you have problems that come up in your transactions, if you have questions that you think of 5 minutes after we log off, please feel free to contact us. We are here to work with you and to help you and to make your businesses and your clients' lives much better. So thank you for joining us today.
Thank you all so much again for your time today. All registrants, as a reminder, will receive a link to the recording of this webinar in the next 2 business days. And should you miss that email, you can also find it on our YouTube channel in that same time frame. And also a big shout out to our public policy and legislative committee members for their guidance and expertise throughout the legislative calendar. And, when we think everyone's going to be on summer vacation and instead we are still talking about bills for next year already. As a reminder, if that sounds interesting to you or another committee sounds interesting to you, our committee applications are currently open for volunteers for the 2026-2027 committee year. For more information about that and to look at all of our committees, please go to our website, the 3 W's, you know how the URLs usually start, .mdrealtor.org/realtor committees. And if you would like to stay up to date, as we already said, on our Realtor priorities and the Maryland legislative session when it comes back around in January, which will be here in a blink, be sure to check out our advocacy priorities webpage, and that is mdrealtor.org/advocacy priorities. Nice and easy to remember. And you can also follow us on social media. Have a wonderful afternoon and a wonderful weekend. Bye, everyone.